So we have two new board members, and we'll start with the swearing, and that's going to be Mr. Dave Matthews and Henry Polsky.
Sherry, just give us 1 minute because it's,
So we have two new board members, and we'll start with the swearing.
Where have I heard that?
we're live, Sherry.
So if you'll stand, raise your right hand. I'm gonna read it. So when I get to the end, all you'll need to do is just say that you do. You solemnly swear or affirm that you will support, protect, and defend the Constitution and government of the United States and of the state of Florida against all enemies, domestic or foreign, that you will bear true faith, loyalty, and allegiance to the same, that you're entitled to hold office under the Constitution and the Charter of the City of Lake Worth Beach, and that you will faithfully perform all the duties of the office of appointed member of the Planning and Zoning Board, which you're about to enter. Thank you. Call the roll. Mark Hum,
Here.
Juan Cotton,
Here.
Sage Chauncey Basha,
Here.
Dan Walewski,
Here.
Evelyn Ortuyo, Dave Matthews,
Here.
Henry Polsky.
Here.
You have a quorum.
No. Let me get up and,
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
okay. Do you have any additions, deletions, recording, and approval of the agenda? Any additions?
There's no additions or deletions or reordering.
Oh, no, we didn't. Okay, would anyone approve of the agenda? All in favor? That are unanimous? Okay. Thank you. All right, so the approval of the minutes of July 19, 2023, regular minutes, and August 2nd, the regular minutes. Is there a reason why both of these are on there? The one was an odd.
Third, yes, that's because Sherry didn't have the minutes finished.
Gotcha. And they were in close proximity.
Yes.
I gotcha. Okay, does anybody have any problems with that, with approving those minutes?
Except I wasn't here for this August 2nd one, but I was here for July 19th one.
I think we're at the point where we may not have enough people voting for them. So unless you saw something objectionable in the minutes, I would just vote for them if you're good with it. If you feel like they provided a summary of the meeting or you were understood what happened at the meeting, you know.
I'll make a motion to approve.
Second,
Sure, I'll second.
okay, all in favor?
Aye.
Okay, so cases, you swear in the staff and applicants, if anybody's going to testify today about your project.
Actually, I'm sorry, I should have noted that in the reordering of the agenda. We're actually going to could we move the training first before we proceed with swearing in? Because we have one of our applicants who's not here yet. So we can move forward with the planning and zoning board training.
Okay, so what would you like to do? You want to do?
Just move the planning and zoning board training next, and then we'll get back to swearing in staff and the applicants.
Then we do the training. What do I need to know?
Well, I just don't know where to start. All right. Everybody can see that, and I believe we're sharing. So we have a couple new board members, and for some of our existing board members, we haven't done our official zoning training or our planning and zoning board members training in quite some time. And this is a good refresh. It's something that I typically like to do with all of our boards annually, and we have had basically a whole new sweep of the board probably in the last year and a half. So basically some very generic history of zoning, where zoning comes from. It actually, it's considered a police power, and it came out of a Supreme Court case in 1926. It was the Village of Euclid versus Ambler Realty. And basically what happened is Ambler Realty bought some property and proximate to Cleveland. And they said, hey, this would be great for a nice big industrial development next to the Sleepy Village. And the Sleepy Village was not super psyched about that. And so they adopted the first really modern zoning ordinance, which regulated use, height, et cetera. So that went through several court cases and ultimately ended up in the Supreme Court, which upheld that constitutionality of zoning, and that it is a valid police power, and it upholds health, safety, and welfare of communities. Specifically to Florida, the state of Florida adopted its first legislation allowing local governments to enact zoning codes in 1939. And then throughout the 1970s and 80s were very active times in the state of Florida related to growth management. And there were multiple legislative initiatives or statutes adopted during that time, including the 1975 Local Government Comprehensive Planning Act, which kind of got the ball rolling on what we understand to be modern comprehensive plans. And we're going to talk about all of that stuff, what each of those regulatory documents are and their relationship with each other. In 1985, you get kind of the legislation that occurred, which is basically what established what we understand to be our current modern regulatory framework for land use and land development regulation in the state of Florida. This was the 1985 Growth Management Act. This required local governments to amend their comprehensive plans, required comprehensive plans, and to ensure that they were consistent with state plans, regional plans, that they had to be certified by what was then known as the Department of Community Affairs, or DCA. Now that is the Department of Economic Opportunity. You may have heard those acronyms thrown around. And it required local governments to enact implementing ordinances, and we refer these to, as our land development regulations, within 1 year of submitting their plans to the DCA at that time. So again, this really, that 1985 Growth Management Act really established the requirement to have a comp plan, for that comp plan to be consistent with the state and regional plans, and for then the land development regulations to then be consistent with the local government comprehensive plan. Some of you who've been on the board, you've heard us say it's consistent with the comp plan and the LDRs. It has to be consistent with both, because if it's consistent with the LDRs, it is consistent. It should be also consistent with the comp plan, because our LDRs are required to be consistent with our comprehensive plan. Okay. There we go. So basically we have kind of those, that very, very brief history of, I'm sure Zaid can weigh in as well, the history of Supreme Court cases and legislation on land use law in the United States and Florida is very deep, and there is a wealth of information there. But that is just basically the primer on the basics that you need to know. Where does all this come from? So our regulatory documents that we have, that we primarily refer to and that you will see, are going to be, one is our comprehensive plan. And again, going back, this is required by the state for us to adopt this, and the components of the comp plan and what that comp plan contains, or in its chapters, which are called elements, all of that has to be based on data analysis, and all of the contents of the comp plan, there are minimum requirements for each of those elements. Then you have our land development regulations, which are, these are our rules of the road. And we'll get into what those are more specifically. And then we also have what is called our major thoroughfare design guidelines. Now, our major thoroughfare design guidelines are part of our land development regulations. So even though it says guidelines, they are adopted by reference within our LDRs, and we are required to review new development against these guidelines. Oh, got excited, sorry. I get excited about land use law. Okay, so again, we talked about, you may have heard, or you have, if you've been on this board a while, you've heard me say or something, and chapter 163 of the Florida statutes, right? Our jam for local government is chapter 163. That's where we live. So we are required to have a comp plan. We are, that comp plan will establish principles, guidelines, and standards and strategies for development, environment, utilities, and that should reflect the community's commitments to its character, what it wants to be, and all of that's embodied in the plan and its different chapters or elements. Public participation in amending the comp plan, and especially in establishing the comprehensive plan, is very important. And in our current iteration of the comp plan, Lake Worth Beach went through several rounds of very large and substantial public input into its current version of the comprehensive plan. There was a tremendous amount of outreach when this was done, I believe, in 2018. And I think there was one bigger update before. I should have pulled that for you. Comprehensive plans have two basic parts, right? First, we have the policy document, and then we also have what's called our future land use map. Our future land use map establishes basically land use or future land use designations. And this is, these are, basically a general idea of how we think that area will develop over time. So our zoning map has to be consistent with our future land use map. The same way our land development regulations have to be consistent with our comprehensive plan. So again, you see the stacking intended by the state, right? The state plan, your plan has to be consistent with the state plan. Your land developments have to be consistent with the comp plan. That has to be consistent with the state plan, right? It's all stacked up, and we're supposed to be consistent this way and this way. So again, this is the comp plan is binding on all development orders. We cannot approve a development order or permit that's in conflict with the comprehensive plan, and you cannot approve variances from the comprehensive plan as well. So again, we talked about land development regulations. Our LDRs are designed to be the implementation of the policies of our comprehensive plan, right? And land developments contain specific and detailed provisions that are necessary to implement this. Well, what does that mean, right? So that means things that you would normally think about with zoning. Everybody's wanted to build a structure or something in their backyard, right? There's a limit on the height of the structure, where that structure can go. What is the type of structure? How high can your fence be? Those are the specific and detailed provisions necessary to implement our comprehensive plan. You can also see that we have a zoning map. And what's really cool about our zoning map is that we have officially adopted our data layers. So our zoning map that you see online is our official zoning map because it reflects the data layers that were adopted in our LDRs. And what's really interesting is that when you click on a parcel on our zoning map, and I can take you to the website later, what you can see is you'll see the zoning district, the future land use, and you'll see links to parking requirements and permitted uses. Is it in a historic district? So that zoning map provides you a lot of information at your fingertips, and that's available live on the web. So it's available 24/7. Again, components of a zoning district. Again, zoning districts have to be consistent with the future land use designation. Right, the future land use designation is the comp plan version of a zoning district. That's its matching pair. And that's going to establish our permitted uses. One of the main applications you'll see is a conditional use application here. And conditional uses are permitted subject to additional review criteria. So that's part of the LDRs. Setbacks, height. Massing is regulated by something called floor area ratio. Impermeable surfaces for buildings and maximum impermeable for all surfaces, which include buildings and paved surfaces. And of course, additional requirements in other sections of the LDRs are parking, landscaping, and subdivision. So you guys will get to enjoy them all on your time on this board. We'll have the full experience. So applications or projects are reviewed for consistency with all adopted regulatory documents. Again, applications and projects are reviewed for consistency with all adopted regulatory documents, including our LDRs, which are land development regulations, and our comp plan. If an application is approved, then what is something called a development order is issued. And a development order is any order granting, denying, or granting with conditions of approval an application for a development permit. And development permits can be building permits, they can be zoning permits, they can be subdivision approvals, they can be ordinances. That is a very, very broad scope of what's covered and what can be under the umbrella of a development order. So who we are, I said who you are, right? Not we. So you are citizens of the community, you are volunteers, you're appointed by the commission. At least 3 of you are required to have professional qualifications related to law, architecture, or real estate development. We have some of you are also citizens at large, and you are here to do is you to carry out the duties and responsibilities as defined in the Code of Ordinances. And you're going to serve kind of in 2 roles. You're going to have an advisory role with legislative proposals, which are the making of law. And then you will serve in quasi-judicial role regarding the specifics of a project in applying the law. So you're going to have 2 different hats. And you're not out there alone, right? You have this wonderful tool that you're going to see, and it's called a staff report. So I would strongly encourage you to at least slightly peruse them before coming to the meeting, even if you don't fully read it all. And ours are set up really where we try to put the bulk of the information you'll need to make a effective quasi-judicial determination in the first few pages. So we try to pack in the earlier pages if you don't have time to fully enjoy all of our exciting writing. I think it's interesting, but it's not everybody's cup of tea. It's definitely not a novel, right? So it's definitely, or a whodunit. So again, we talk about understanding your role. Your first role is going to be advisory. So some of times you're going to be advising on legislative actions, and sometimes you're going to be advising and through the quasi-judicial process on specific actions or specific development approvals. So when you are advising, you are providing a recommendation to the city commission on an application or on a legislative action, like a new or an amendment to our land development regulations. So this is going to be our plan developments, our sustainable bonus incentives, TDRs, rezoning, comp plans amendments, right-of-way abandonments. Our existing board members, we've had a little bit of taste of everything this year. So, and again, you're going to provide a recommendation, not on your personal feelings about the project, but you are going to provide a recommendation on whether that project is consistent with the comprehensive plan and the LDRs, because that is your role. And you also have a second role where you are the final decision makers, right? So this board has is a very, very important board in the city, because you are one of the few boards that has an advisory function as well as a final decision-making function. This would be variances from the land development regulations, developments of significant impacts, major site plans, and conditional uses. And again, you are reviewing for consistency with the city's comprehensive plan, LDRs, and major thoroughfare design guidelines. So I'm going to turn this over to our city attorney now. And she's going to walk through some of the things, rules of the road that you need to know, and on how to be an effective board member.
Hi, everybody. My name is Elizabeth Linehan, and I will be at all or most at least of your meetings. If you all have questions related to your time on this board and other things that come up from a legal nature, I will be your contact. So I will have some of the slides as part of this presentation. We're going to start tonight with meeting proceedings, generally how they operate. So you'll prepare for your meeting at home, you get a staff report. And that's, as Erin said, highly encouraged that you peruse that before you get to the meeting. Once you get to the meeting, the chair has the agenda and they follow that, really opening the meetings, following, roll call, pledge of allegiance, additions, deletions, modifications. You all heard all of this already this evening. So the meat and potatoes of what you really are going to get into that we'll talk about tonight is that those public hearings that will start for you or some of you this evening. And as part of those public hearings, you have to pay attention to whether or not you have any disclosures to make, how the quasi judicial procedures operate, what are you looking for, how do you have to behave, what's the proceedings, and what are your obligations as a board member, how motions are made, and then one of the main things that's really important for local government bodies is public comment. It is required by Florida statutes that all matters that are decided by a body have to allow for public comment before a decision is made. All right, so calling for board disclosures, you will notice in your agenda, there is a specific spot for board disclosures. There are two types of disclosures that you as board members need to be aware of. There are ethics disclosures, which are voting conflicts of interest. Those there are state requirements for voting conflicts of interest, and there are Palm Beach County requirements. Palm Beach County, as a charter county, adopted its own code of ethics, and it applies to all of the municipalities in the county. So you all are subject to those as well. They are stricter than the state requirements. There are also quasi judicial disclosures, including ex parte communications. And again, there are also state requirements and city requirements for what you have to do. So in the ethics, the voting conflicts, Palm Beach County rules state that you as public officials shall not use your office or position to take or fail to take an action or influence others to take or fail to take an action or attempt to do any of those things. If you know that would, with a reasonable care, exercise reasonable care, result in a special benefit not shared with others similarly situated. So typically the way the ethics boards at the state and local level qualify that special interest is if it would impact 100 people or more, then you're safe. If your decision or the matter that you're voting on would impact fewer than 100 people and it impacts you or one of these other special people we're going to talk about, then you would declare a voting conflict of interest. Your voting conflict of interest is that you abstain from voting. You declare on the record, I have a voting conflict of interest, who the special benefit would run to, whether it be you or one of these other special people or many of the special people that are included in this. And then there's a form that you fill out within 15 days of the vote. And Sherry and I will help you with that process.
And we also ask that you also step out of the meeting during the item that you have a conflict with, to not influence the discussion of the body and to make it clear, and that's to protect you.
So this is the list of conflicting relationships. So if again, that special benefit would apply to you or any of these people, that's what you have to be conscientious of. So for any project that comes before you, you're looking at, where is the project located? Does it impact me? Does it impact any of these people that are on this list? More so than it would impact other people in the general community of the city. And if you think it will, if that project that you're supposed to vote on is across the street from your sister or down the street from your aunt, give me a call and let's talk about it and see if there's something for you to declare. So again, real quick to finish up on the disclosures, like Aaron said, because Palm Beach County rules are more strict than the state rules, they prohibit you from voting and from participating in the discussion on the matter. And that's why we ask you to step out, because you can't vote, you can't discuss it, and you can't be seen to influence your fellow board members. So they can't see you making facial expressions or, you know, shrugging them a certain way. So we just always ask if you have a voting conflict, that you step out of the room for those. All right, so quasi judicial proceedings are used when a local government applies a specific rule to a particular situation. And so like Aaron said, a lot of the things that you all do, you're applying the land development regulations to a specific property. So if a specific property is asking for a different height of their fence, you're looking at that and saying, how do the rules for fences apply to this specific property in this specific request, right? There are certain procedural and substantive thresholds for quasi judicial proceedings. You have to make sure that everybody has due process. And there's standards of review you have to meet, and everybody will present evidence. The staff report that you get from Erin and her staff is some of the evidence that's part of that hearing. The applicant will also sometimes bring evidence so far as a slideshow presentation or other handouts or documents for you to look at, sometimes poster boards. And those are the things that you're supposed to consider when you're in a quasi judicial hearing. Competent substantial evidence is what the standard that you're looking for. When it's presented, then you are basing your decision on that evidence that either the standards that are in the LDRs have been met, or if you're going to deny, that a denial would accomplish a legitimate public purpose and not be arbitrary, discriminatory, or unreasonable. So usually staff will, in their staff report, present to you a recommendation, and they give you the information to back up that recommendation. If you want to make a motion or make a decision that is different from what staff has recommended, you'll need to put additional information into the record to show with competent substantial evidence that the decision you're making that is different from the recommendation that's been presented to you is not arbitrary, discriminatory, or unreasonable. It's backed by competent substantial evidence that is in the record, either in the staff report or in the presentations that are given at the hearing. Okay, in the city's land development regulations, this is the quasi judicial disclosures that we were talking about. You have, if you in your quasi judicial role, if you believe that you have a bias or prejudice for or against a party at the hearing, if you have a direct or indirect monetary interest in the outcome of the hearing, a prejudgment of the issues prior to the hearing the facts on the record, or if you've had ex parte communications, then you have to make that disclosure that you have had any of those things. And then if you say, yes, I have this, then you follow up with whether or not you can still serve as an impartial hearing officer, because that is your role in a quasi judicial proceeding, is that you are looking at the evidence presented at the hearing as if you don't know anything about the property, you don't know anything about what they're asking, you're hearing it all for the very first time with no judgment or bias in your mind. So you haven't been to go investigate the site, you haven't talked to anybody about it, you haven't made up your mind already before you get to the hearing. Those are the important things that you're looking for, is you've come in with an open mind about what you're going to hear at the hearing. All right, so ex parte communications is that last bit that we were talking about in the last slide, and it's discussions with, written communications, or investigations and site visits that you make as part of your looking into an item. So sometimes the applicants, I don't know how much it happens on planning and zoning board, but I know a lot of applicants like to contact their elected officials and have discussions about what their project plans are, and kind of try to garner some support for their project. If that happens, you have to disclose that you have had ex parte communication with that applicant. If you come in and talk with staff and get some more details from staff because you're having a hard time understanding this piece of this staff report or what the developer is really asking, then you disclose that you've had that conversation with staff even. If you just drive by the site every day, but if you drive to the site and get out and walk around and, take some measurements and really investigate the site, then you need to disclose that, okay? So that's ex parte communication. Under state law, ex parte communication is presumed to be prejudicial. That's why you have to disclose it. So the applicant knows that you have had ex parte communication, that that removes the presumption of prejudice, and they can ask you questions about the ex parte communication that you have had, and you have put it on the record that you've had this additional communication. Things that aren't just presented at the hearing.
And there are different board members that have different levels of comfort with ex parte communications. It does, you do have to really clearly disclose them and to protect yourself. If somebody calls you who is an applicant, you don't have an obligation to call them back. If you feel uncomfortable taking that call and then disclosing it later, you could just choose not to speak to that applicant, or if they email you. So then you will have avoided having an ex parte communication.
If you receive an email from an applicant, send it over to staff and make it part of the record. That way it's disclosed. You say, I got an email, I read it or I didn't. I sent it to staff, they have it. It's part of the record because any written ex parte communication needs to be made a record of the hearing. Yeah.
So I always wondered this, but I guess I've been guilty of it once or twice. When we're reviewing the project, everyone's showing up, got my laptop here. I'll pull it up on Google Earth just because I'm having a hard time seeing exactly where it is.
You really shouldn't, you really shouldn't be doing that. You should be, whatever you're looking at, everybody really needs to be looking at in the quasi judicial.
Sometimes the map is kind of small and
So-
like I'll have the property in my mind, but I won't remember if it's the one. north.
We can pull up a
So
Google
you
map.
say,
Yeah.
staff, can you pull up Google Earth and let's look at this in real time? And
Okay.
staff will do that because one of the points of ex parte communication and disclosing it, and specifically that, paying attention to what's being presented at the hearing, is so that all of you have the same information. So if looking at a Google Earth map would be more helpful to you than the tiny little map picture that staff has put up there, ask. It's probably beneficial to everyone, right? Good question. Okay, so that's your board disclosures for ethics and quasi judicial proceedings. Then skipping back to just kind of how the meeting runs is the next thing would be, once you hear all that evidence, then you're making motions. Motions can be easy, they can also be tricky. It just depends on where you are in the hearing and what you want to do with it. So anybody on the board except the chair can make a motion. If nobody is making a motion, or if the chair feels really eager to make the motion, the chair can pass the gavel and then the chair can make the motion. Anybody, including the chair, is allowed to second a motion. The chair is usually the person who's going to be recognizing the motion maker and the seconder and what the motion is. Okay, so if the motion maker goes with I move to approve, then the chair says, I have a motion to approve made by, Mr. Hum. Do I have a second? Whoever calls a second, I have a second by Mr. Shamsi Basha. All in favor or all opposed, and you all would vote yea or nay accordingly. The chair then records, and so that the secretary has, the motion, either the motion is unanimous or the motion passes 3-2 with and names who is usually dissenting, whoever's in the minority, because then there are fewer people to name. And that's how the votes will go. We have to do verbal motions. You do have to vote on every motion unless you have declared a voting conflict of interest.
And sorry, I was gonna say something, I totally forgot. It'll come back.
It will come back.
A quick question on, say for instance, tonight, if there's a motion that comes up that was previously discussed, then I shouldn't be voting on, it, correct?
There is nothing tonight that was previously
Well, I'm
discussed.
just trying to.
So sometimes there will be an item that's continued. And so if it's continued and we have a new board member on board, then what we'll do is we'll provide the minutes, and then we'll also provide a summary of what occurred. So typically when an item's continued, staff will open the presentation and say, here at the discussion at the last meeting, the board was looking for this additional information from the applicant, and the applicant's here, and then we'll basically continue the public hearing.
Yeah, I've seen that before, that's why that.
But once you're seated on the board, you are required to vote.
Okay.
So if you need additional information, speak up and ask the questions, new board member, I didn't hear the first time. Could you explain this part to me? Don't be afraid to ask questions or speak up if you need additional information.
And I will say, we generally use Robert's rules, but we're kind of loose and fast with them. So we just want the meeting to be orderly. Don't speak over each other, wait to be acknowledged to speak, be courteous. If you want to make a motion or a vote that does not agree with staff's recommendation, that's fine too. We will help you procedurally through that process, but you are going to have to provide kind of the reasoning and the evidence to support that deferring motion. So I know everyone who's been here, not everybody sees eye to eye exactly with our recommendation, and that's fine. And that's what we're here to provide a recommendation, provide our professional expertise, but also to assist in the facilitation of the meeting and then the resolution and the decision on these items. Okay.
You will not hurt staff's feeling if you disagree, and we will help you work through that, making the motion that you want to support. Okay, so you all, a majority of your quorum is going to be 3 members or over 3 members, and you need at least 3 members for specific approvals. So that should not be an issue.
4. Oh, we need 4 members
Yeah.
for quorum. Okay,
Right.
3 for an approval.
Okay, as I was saying, public comment is required by Florida law. Typically, on each agenda item before a vote is taken, the chair asks for public comment. And so that gives the public an opportunity to speak specific to that agenda item. That helps keep the agenda flowing, and it also helps make the public comment specific to the item. You also have a spot on your agenda for public comments on non-agenda items. That gives the public an opportunity to come and speak on any planning and zoning related matter related for the city and talk to you all about it. There are rules for public comment. Typically, it's 3 minutes for public comment. That is not something that's really been necessary to enforce with this board because there is usually very little public comment. That's for
I think-
board and
Oh, I just copied your historic preservation slides. I'm sorry.
That's okay. So, and when it's public comment, just in general, there's no response necessary. If you feel like you want to give a response as a board, you certainly can. It should be on planning and zoning related matters. And when it's related to an agenda item, it should be specific to that agenda item. Again, no response necessary, but if you think it's important to provide one, that's up to you as a board.
We recommend you don't.
Yes.
Sorry. Okay, so we've had, that's come up before where, and I was always kind of unclear on that. I know we're not supposed to go back and forth with public comment, like we say something, they say something back, that's not the intent of it. But there's something different where somebody can identify, I believe it's an affected party, or there's somewhere where someone can give
Yes.
testimony who's a neighbor or something else. And I don't think that's always clear necessarily in the audience when we're swearing in, if they're giving public comment or if they're an affected party.
Right.
What are the conditions to be an affected party?
So that is another one of the components of quasi judicial proceedings, is that as part of your due process, the applicant and anybody who is considered an affected party here in the city is what they call it. And it's somebody who lives or is going to be more affected than other people in the community by the decision, by the project. And so usually it's a next door neighbor, not somebody who's 3 streets over, but lives very close or owns property that's very close to the project. So they have to file paperwork that says that they are to claim as an affected party. They have to show that they meet the criteria as an affected party. And then that gives them the opportunity, similar to what the applicant has, where they can give testimony, they can cross-examine witnesses that the applicant puts on, the applicant can cross-examine them and their witnesses, and they can bring evidence forward for you to consider. Yes.
So if the applicant objects to someone in the public being designated as an affected party, they have to raise that objection.
They have to raise
And
that
then-
objection.
In that situation, we would have a proceeding to determine if that person is an affected party.
So we have had this come up once, and we probably would talk about it again before we brought it back. So there are a couple different ways you can handle it, and one is to bring it to you all to determine if that person is an affected party. The other is to note the objection on the record and let the proceedings carry forward with the person acting as an affected party. The concept of the affected party is that that person would have standing to bring a challenge to the development in court or to the decision. So they're that close to it, they would have standing in court. And of course, if they ended up going to court and filing something, the challenge would be the challenge to their standing would be brought to the court for determination, and the court really is the appropriate party for that. So at the local level, if it's a decision that you all would be making, it would be you to decide if they met the criteria for an affected party. But it is also appropriate to just note the objection on the record and let the proceedings continue.
And our internal discussions have kind of led us to prefer the notation on the record. Because what can happen is if it goes to court and goes to the higher court, they can remand to the lower court if they didn't feel necessarily the decision was incorrect, but that the affected party was denied due process.
Right.
So a more conservative approach is to allow for maybe excessive due process.
So my
You know.
question is, the applicant has due process rights as well to not have random people come in, cross-examine them, unduly burden the proceedings. So I mean, there are cases where the city has been reversed for allowing, so I'm just, throwing that out there.
It is, we do
There's
have
no
a
good
very,
answer.
right, we have refined our affected party rules. And it is a person, and so it's a property owner within 400. So there are certain things before you even get to that threshold that we believe would yield to standing. We believe we've established thresholds that would yield standing in court as well. At a minimum. Now, if there's still some vagueness, we could bring it on a case by case basis, but as a rule, what we've said, rule of thumb is we feel it's better to be more conservative and honor more due process than to risk the possibility of a remand based on due process.
In their case, they would have to ahead of time, file whatever paperwork, so someone
Yes.
can't walk into the meeting and say, well,
No,
I want this standing because I'm a neighbor, they would have had to have done that.
no, they have to do it in advance of the hearing. They work with staff to make sure that they meet the criteria and we have their reasoning, for, what they want to bring forward and those types of things, because we have to coordinate the hearing. If there is an affected party in particular, we make sure that the chair has a script of how the order of the proceedings go and try and help keep it organized.
We try not to torture Juan too much. I mean, just for fun. But I will say, too, with the whole, the script and the affected parties, if you miss your deadline as an affected party, you don't get to participate in our hearing as an affected party, but it doesn't negate your standing. If you have standing in civil courts.
Right.
Our determination or our rules about affected party doesn't negate your standing in court. So those are two different processes. This is our process, and we believe it's a conservative process to, like you said, to not negatively impact the applicant's rights for due process. And it's the balance we've been able to achieve.
And if it's a proceeding that where you're the recommending body, they also have the opportunity to file as an affected party at the city commission. Alright. Okay, some very, very basic stuff about volunteering for local government. Thank you so much for volunteering. You are now subject to sunshine law.
You're so lucky.
Yeah. This is your reward. Okay, so sunshine law was created by the Florida government to protect the public from closed door decision making. It applies equally to elected and appointed bodies. So it applies to all of you as you have been appointed to this board. It prohibits discussions between two or more members who sit on the same board on matters that may foreseeably come before that board for a decision. So discussion can be face-to-face communication, a phone call, notes on a napkin, text messages, social media posts, emails, anything. Okay, this doesn't mean that, well, I wasn't staring them in the eye, so it doesn't count, right? Does it matter when or how this discussion takes place? Absolutely not. It can be in your private time, it can be in a government office, it can be while you're on vacation, doesn't matter. So all of those communications are important.
And we just strongly encourage you to stay off social media, not for baby pictures and travel pictures, but for anything related to a project, is to not respond, because that you're going to have to disclose that discussion. It's better to not.
And as Aaron said, social media, look out for that, particularly when it relates to a project. So don't go scrolling for it. Don't read the comments on the post about, the developer's site, because all of those things would be ex parte communication that you would then have to disclose. If you are posting about it, it may be, you have to make sure that none of your other board members have posted. You can't respond to them. That's a sunshine violation. You have to keep it as a public record. There are lots of things related to it, so just don't. All right, so while you can't talk to each other outside a noticed public meeting such as this, you may talk to staff at any time. Sunshine law does not apply to staff. However, if you want to use staff as a go-between to say, well, I can't talk to my fellow board member, but you can. So will you tell them?
No,
That's a problem.
we don't do
You
that.
have made them, you have made sunshine applicable to them. Also, if you make them part of the decision-making process, so you say, well, we're going to do this, but staff will have the final say. Or staff, we need this from you or that from you. If you give them a part in the decision-making process, then staff is subject to sunshine as well.
I will just add, though, if you call us and you say, I read your staff report and I still have some questions about this issue, could you bring additional documentation or clarification to the meeting? That gives us a heads up, and then that allows us to prepare that additional information, and then we will share it on the record as part of our presentation.
And again, if you have questions, other people probably have questions too. So it's beneficial to everyone for staff to provide that information at the hearing. All right, so that was the very basics of sunshine. I'll give you the very basics of public records law. Public records law applies to any document made or received in the transaction of official business. Your official business is the city of Lake Worth Beach planning and zoning issues. So it's pretty broad. You didn't change my slide again.
I didn't change your slide. I didn't know she had specific references to HRPB. I'm sorry.
It does not matter who the record is from or who it is to. It's just that it is either to or from you, okay? And again, doesn't matter how or when the record is sent or received. It can be, you know, again, on your personal computer, it can be on your phone, it could be on a government issued device, it doesn't matter. It can, and it doesn't matter also what format the record takes. It can be a map, it can be a staff report, it can be a huge blown up check from Publishers Clearinghouse. It can be notes on a napkin, social media posts, emails, text messages, faxes, air balloons. It can be anything, okay? So what matters is what the content of the record is. If the content of the record is related to your work with the city of Lake Worth Beach, particularly planning and zoning related matters, it is a public record. My recommendation to you is if you make or receive such a record, that you send a copy to staff or you send the record to staff. And that way they have it. If there's ever a public records request, you have turned in all of your records. You don't have to go back and look to see if you've had anything. You don't have to worry about, did I keep it for the required public records retention period? You don't have to turn over your device for scrutiny by the court because you're not sure if you have it or not, or you may have accidentally deleted it and they need to check.
And you can be required to turn over your personal cell phone. So do not text people. You know, email, you should not be engaging in ex parte communication unless you disclose it, and we would recommend you don't. But even further, if you're going to engage in ex parte communication in a written manner, do it via an email, then you can forward that email chain. But text messaging can lead to questions about, do you have other texts? And
If for some reason you have text messages, a friend says, hey, I was wondering about this development. You're on the planning and zoning board. Can you tell me about it? You can say, pick up the phone and call them and say, this is what I know. You can say, I'll send you an email, or just send them an email and say, this is what I know. Contact Sherry Cole. Okay. If you're not sure if it's a public record or not, give me a call. We'll talk about it. If you have public records, send them to Sherry.
more ethics.
Yay, everybody loves ethics. All right, so in addition to your voting conflicts of interest, the other things that you need to be aware of are that you are not allowed to use your public position to secure privileges for yourself or others. You cannot enter into contracts with your agency, which means that you cannot enter into a contract with the city of Lake Worth Beach, really for any purpose. But if you have a question about that, give me a call and we can go through the specifics. You cannot accept directly or indirectly travel expenses from people who are involved in the process with the city of Lake Worth Beach. And you also are not allowed to pay or give a contingency fee to another person related to your duties with the city. You also, thought I was done, right? Don't accept gifts. It's a bad idea. Thank you for your volunteering with the city on planning and zoning. Here are tickets to the fair. No, thank you. Okay.
Even if it's a $50 gift, I just
Don't take it.
don't take it.
Really super easy on that one. Don't take it. Also, don't ask for gifts.
Buy
in-
your own coffee.
Yeah.
All of it.
All right, so that's kind of the basics on that one. Do not take or accept or solicit gifts.
Yes.
If you want to take some training, there are links here that we can send out to you. There's state required training is not required for your level, but it does include sunshine, public records and ethics information, so it is really helpful. Palm Beach County does require you to take training, and there's the link for that as well.
And I just want to note that this is our current webpage. All of our regulatory documents are on our webpage, including lots of great information. You can see also on our planning and zoning webpage, there's a little button to our zoning map as well. The city is going to, in the next month or so, is going to update its webpage format. I'm really excited about the planning and zoning and historic preservation pages. I think they're going to be a lot more user friendly and provide a lot of information to the public. So we're looking forward to seeing that webpage roll out as well. And congratulations, you made it through. Thank you. That means a lot coming from an attorney. So
Learned a lot more the second time after having been on the board for a few years.
yeah, there's a lot.
It's a lot of information all at once.
I mean, I tell people all the time, I'm like, they think they coming on the planning and zoning board. It is fun. Okay, there is a fun. You are making important decisions and influencing things that happen in your community, but this is serious business here. And it's serious legal business too. So that's something that's very important to remember. And as here, now that we've made you really tired, do you want to take a 5-minute bio break, as they like to say now?
Okay.
You were all good?
Yeah.
All right. So I would say, Mr. Chairman, I believe we are at swearing in staff and applicants.
Okay. Lovely presentation. City Attorney, thank you. Okay, we swear in the staff and the applicants, if you are going to testify today on anything.
If you're going to speak today,
Can you
rise.
please stand up,
mhm,
raise your right hand?
Do you swear and affirm the testimony you give will be the truth, the whole truth, and nothing but the truth? If so, say yes.
Yes.
Thank you.
All right. The proof of publication, we have two, 1806 Newburgh Avenue and 1778 7th Avenue North. Do we have that proof of publication? Yes?
Yes.
Okay. Any withdrawals or postponements? I see none. Okay, board disclosures. I would like to disclose one thing, that there was on the existing structures, the first project, I believe here, I was called by a vendor and spoke to me a bit about the project. Unfortunately, that vendor, we have another project that I'm working on, and I'd like to excuse myself from the board. It's a different project. So I don't know if that counts. I had a brief conversation about this project. So,
So the vendor who you spoke to worked on this project
been working on
and is working on another project
with me separately.
with you separately, but they would be considered a client or business associate.
Absolutely.
Then yes, you would have a voting conflict of interest. So if you have declared your conflict, you'll fill out the form for Ms. Sherry over there and.
Juan just wanted to go sit outside. He's tired from the training. Go ahead.
So who's the vice chair ready?
We haven't done, that's the other thing that we need to do is we need to do our board organization. So we thought we'd let you guys meet each other and get through a meeting and then we'll do the vote. But I would
Now
say,
you need a vice chair real quick.
well, I think, isn't Dan the vice chair?
Yes.
Yeah. Yeah, so we'll do it. I think we're good, actually. We can wait, guys, until January to do our organization meeting. One less thing.
The outside.
All right.
Okay, so ready for the staff reports?
Right.
Good evening, Mr. Chair. For the record, Scott Rodriguez with Planning and Zoning. The item before you is the dry dock boat and RV storage major site plan request for installation of a 34,000 square feet of canopies for previously approved recreational vehicle and boat storage spaces located at 1778 7th Avenue North. Thanks. The subject site is located north of 7th Avenue, west of I-95 and south of 10th Avenue, and is within the Industrial Park of Commerce zoning district. The background is just basically a timeline of the initial approval from 2022. And an administrative time extension was requested and granted in 2023. And a submittal of building permits for the site improvements were applied for also in 2023, and at this point, there's no active code cases on for the subject property. This slide is showing the approved 2022 site plan versus compared to the proposed, which is showing the canopies in red. The canopy structures are metal poles and a roof that cover the approved parking areas and provide protection for the RVs and boats from the sun and elements. This slide is showing basically an example of what those might look like. The site plan also implements a condition of approval from the city engineer related to queue distance to the front driveway access gate. Sorry about the, I didn't put the arrow in there, but this is a zoomed out version of that area that's being addressed with the minor site plan. There are no changes to the approved landscaping. The applicant did provide an updated plan to show that the new canopy structures will not conflict with plant materials. The landscape plan is proposing adequate perimeter and right-of-way landscaping, and the vegetation will provide screening from the surrounding properties. This project is consistent with the comprehensive plan, strategic plan, and city LDRs, and staff is recommending approval with conditions. And that concludes my presentation.
Thank you. Do we have any, is the applicant here tonight that they'd like to address the board?
Right. Shane Brunix with Urban Design Studios. I'm representing the Happy Younger Greystone Industrial Properties. I don't know if you need a full presentation. Scott did a great job, so mine's kind of repetitive, so I can
He
see.
usually does a great job. Does the board, anyone need a bond?
Okay, I'll be here to answer any questions.
Any questions for the applicant? Okay, any questions from the board to staff? All right, moving past. Would someone like to make a motion?
We do have public comment.
Public comment. I'm making that pass.
You missed
Is there any
that
public
slide.
comment on this issue? Come on up, please state your name and address.
Good evening. My name is Claudia Rodriguez. I'm the owner of the property that is across there. Unfortunately, I'm not disagree with the project. I'm not agree with the project because that is the reason we have all of you to make the decision. My only concern is the traffic. And I don't know who is the one that is in charge or make a signs, speed, stop, no make a U-turn, all of those things. That is the things that I want to, you be aware of those. I was listening everything that they said that you could not go to the play, you could all those things. I take some pictures, but I'm not giving you the pictures because today I'm not acting as a party, affected party, only as making comments. And that is my point, yeah, because before they only have one tenant, that is the tower. Now they will have 93 tenants plus the tower, and the traffic 15 years ago is totally different than now. For example, now that they have the tower, they don't have a space for parking when they go do maintenance, put all of those in the tower. And I don't know anything about the project. Looks beautiful and everything. Yes, that is for parking things. But what happened when the husband bring the wife with the kid with another car, all of those things where they park? Only I'm putting all of those questions. Maybe, they already take in consideration all of those things, yes? The most critical thing down there is the traffic. Because we have the railroad, we have a curve that is very narrow. There is no signs for speed. There is only one arrow, and that arrow, that traffic arrow is there, but because I caught millions of people, and unfortunately, the day that they went there to post it, I missed the person. If not, I will ask the person if I can pay and put 2 more, because when I bought my property, used to be 3, then was none. Then when I called, they put 1. That is the only thing I was saying, traffic. Traffic is the 3. 93 tenants is totally different than mine.
Thank you. Based on that, I have one question for staff, and I think it's pretty easy, but this is a parking and storage. I know a typical kind of boat yard. People would be coming out there potentially doing maintenance on something. You're not allowing people to go out there and do maintenance on their RVs, boats, and sanding the side or anything like that. This is just parking and storage, right?
Correct, yes. I will just note that this was a previous use approval many years ago. It came in for the major site plan only. And when was the major site plan? It was in 2021, 2022. And the major site plan was only for the improvements related to the previous modification to the improvements related to the previous use approval. And then this is just a modification to the site. So the use has been,
Well, parking has already been approved. This
the
is just
parking,
adding canopy.
this is just adding the canopies, and then that's what this is. And typically, like if an applicant is doing something like adding canopy or doing something, we can typically keep this at an administrative level. The issue here is that there are thresholds in our code. And so the volume of canopies that they're adding triggered our code and required this to go before the board, but they're not changing the use. They're not changing the operations of the use. They're just adding the canopies to the previous site plan.
I have a quick question for staff. So one of the, if I recall, one of the condition or proposed conditions of approval is, the city engineer has to sign off on the traffic flow and I guess traffic pattern of the inside the site. Is that correct?
I believe that was related to the stacking distance, because the city engineer was unsatisfied at the time of major site plan approval with the proposed stacking distance, especially based on the size of the vehicles. Because the road is narrow, they wanted to have a full stacking distance to accommodate the largest vehicle. And I think, Scott, is that what you were, is this can you speak to that? Sure. What you've done?
See on the plan, it does show the 50-foot setback from the gates.
Okay,
So-
I don't have that off the top of my head. I don't remember.
Yeah, I don't actually have the verbiage of the condition.
Yeah, I do believe that was one of the conditions. So this current project is addressing that condition also.
Along with adding canopies, yes.
Yes.
Any other questions? Make a motion to approve. Thank you. Second. They want to, for the record.
Wait, go back, go to the motion slide. Okay, almost right. We're gonna just do it again, close. So, it's in your staff. Do we not have it in the motion? So if you can look in the last page of your staff report. Page 6. You're gonna make a motion to approve with conditions, project number 23. So you're just gonna read that.
Okay. There you go.
There you go.
If you were recommending that we change things or alter any staff recommendations, you could read that in your motion. But bring that conditions, and that's. very much.
I like the initiative, so thank you.
Okay, can I go?
Go,
Yes.
do it.
Okay.
Let's do it.
I move to approve with conditions of PZB project number 23-014-00025 for a major site plan amendment for the installation of 34,454 square feet of canopies for previously approved recreational vehicles and boat storage spaces at 1778 7th Avenue North, based upon the competent and substantial evidence provided in the staff report and in the testimony at the public hearing.
Okay, we have a second?
Second.
Second, all those in favor?
Aye.
Aye. Any opposed? Passes unanimously with one staying or recusing himself.
Perfect, thank you.
Gold stars all around, everybody. Thank you,
Welcome
Danielle,
back, Juan.
for ably chairing the meeting in the absence of one.
Exciting right off the bat.
PPP project numbers 3-00500 Commission refund for a 6,800 square foot contract at the showroom at 106 Madrid Avenue. The subject site is located within the industrial park and commerce, I-POC zoning district, and has a future land use designation of industrial I. Comment in that area. Okay, staff, words of enlightenment.
Definitely. Well, good evening. For the record, I'm Abraham Fogel, and I'll be presenting this item. So here we have the site location. It's generally located east of Madrid Avenue, west of the FEC Railway, and south of 10th Avenue North. The proposal is for a conditional use to establish an approximately 6,800 square foot contractor showroom classified as medium intensity because it's less than 7,500 square feet. That's a threshold in our code. The business is King of Kitchen and Granite, which has an existing warehouse within the same building and is looking to expand to this portion of the building to establish that showroom for cabinets and countertops. They are anticipating a total of 3 employees with hours of operation between 9 a.m. and 5 p.m. during weekdays and 9 a.m. to 2 p.m. on Saturdays. Again, if approved, it would establish this showroom within the existing building, which would be open for wholesale use in industry professionals. This is not your typical retail store just for regular customers. These are for industry professionals and wholesales only. Here we have the property survey. It's a little bit difficult to see, but the 10th Avenue North overpass is here to your right. This is the floor plan for the showroom, which again will encompass approximately 6,800 square feet. It is staff's analysis that the proposed request is consistent as conditioned with the comprehensive plan, strategic plan, and the applicable land development regulations as outlined in the staff report. Based on the data and analysis provided in the staff report, the use is not anticipated to negatively impact adjacent properties and will be compatible with the neighborhood. Therefore, a recommendation of approval is provided with conditions.
Abraham, can you go back to the slide that talks about the findings for conditional uses? And I just want to go over this just because we have 2 new board members, is when you are reviewing a conditional use and you are making a motion to approve that conditional use, you are essentially making findings that the conditional use is or you're making findings to determine its consistency with the land development regulations. So what we do is we provide the findings in the staff report. They're typically in a table in the back. And we'll say in compliance, and there'll be a small paragraph of analysis summarizing the analysis that staff used to determine whether they were in compliance or in compliance with the condition. So I just want to call your attention to that. And so when you're making that motion, that's what you're saying. You're saying that that you are making the determination that this use as it is proposed in condition meets all of these essentially review criteria.
So I have them up on the screen. As Aaron mentioned, we usually do a summary paragraph in the body of the report, but then at the end of the report, you can always look for the attachment where you can see each item and we're indicating if it's in compliance or not, or if they're reaching compliance through conditions of approval. Get back to our slide. That was it for the presentation. I will just quickly bring attention to our conditions of approval. They are typical, except for number 4, 5, and 6. There is a previously approved landscape plan on file. So we are conditioning, it's difficult to view the property from the right of way due to the overpass and the access on Madrid Avenue. So we are requiring a site visit just to verify the conditions of the parking lot and the previously approved landscaping. If there's any deficiencies with that, they will need to submit a landscape permit so that it is supplemented. As indicated in the staff report, there's currently an open lien on the property, so they have to resolve that case. And if there are any fines, they have to pay that to the city to move forward. And lastly, throughout the documentation of the property, there are some inconsistencies on where parking is located. So we want to see that rectified. If there's any unapproved outdoor storage, that's removed so that the circulation and parking on the property are clear. There's also an older pole sign on the property. There's currently no signage on it, and it's technically a prohibited signage. So they will have to remove it. Again, on that site visit, we'll see if it's somehow integrated with the building. If it is, we can work with them. But if it's just a standalone pole sign, they'll have to remove it and come up with different signage, which we would review at permitting. But that's it for my presentation, and the applicants are here to answer any questions.
I do want to touch on code enforcement actions though, and new zoning approvals. So we cannot process an application if there is a code enforcement fees on the property unless that zoning case facilitates the remedying or I guess remedying the code, the code case. So in this case, we felt comfortable moving forward with the action to approve the new use because we conditioned it so that the lien would be resolved and that the issues related to unapproved outdoor storage in off-street parking were mitigated.
And just adding to that, you'll notice too, with a lot of our conditions, we put timing into them. So after they get approved with you guys, they have to take care of these items before they get the business license, which you need to legally operate the business. So particularly for 5, you'll see that they need to take care of that before we issue them a business license.
Good evening. My name is Mauricio Valle. I'm the owner of the King of Kitchen.
Your presentation, you just for any questions that we might have.
Do you have any, I don't have any questions. Have any questions?
You know.
I guess you're familiar with all the conditions that staff has and you're good with all of the conditions that are part of this approval.
Yes, all the conditions, Mr. Abraham, have been gone over all those conditions. Yes, we're familiar with it, and yes, sir.
Thank you.
You're welcome.
All right, any board comments?
I just have a question for the staff. Being new on the board with all those conditions that we went over, when it comes time for a motion, excuse me, and we say approve with conditions, does that cover all the conditions that we have spoke about or that is in the, just wanted to make sure. Thank you.
It covers, when you say that motion, it covers all the conditions that are stated in the staff report. From time to time, you may want to delete or amend or add conditions, and so you do that as part of your motion.
Even with some of the conditions have different time limits,
Yes,
the business, where it states, number 5 about, or number 6 about the business license. All those have to be completed before that business license is issued.
Yeah.
Thank you.
Okay, is everything from the public? Okay. That is it. So at this point, we have any motions from the board?
I move to approve the conditions of the DD project number 23-005-00013 for conditional use permit based upon confidence, substantial evidence provided in staff report and in the testimony at the public hearing.
Second,
I'll second.
okay, second. Take a vote, all in favor?
Aye.
Okay, unanimous. Thank you very much, sir. Okay. So. Planning issues, there's always planning issues. Do we have any other planning issues?
We don't, Mr. Chairman, we figured we'd given you enough tonight to.
You guys don't like conferences?
I mean, I feel like we could have done a panel, like, next time, listen, we're gonna coordinate, we're gonna make it happen.
Okay, public comments, and I see a lady here. Would you like to make any comments? Miss?
I'm doing.
Okay, thank you very much. Okay, department reports. You guys have lots of reports.
Not today, no department reports.
Okay. Any board member comments other than welcome to the board, to board members? Anything else from you guys? All right. We are adjourned.